Your landlord is lying to you about your deposit. Here's the proof. Most tenants lose their full deposit, not because they trashed the apartment, but because they didn't know 3 specific things the law says landlords cannot do, and landlords count on you not knowing. The average security deposit in the United States is $2,400. That is money you have already paid. It came out of your bank account. It sat in your landlord's account for the entire length of your tenancy, and the question of whether you ever get it back depends entirely on whether you know what we're about to cover. Here's what we're going to cover. First, the itemized statement rule that most landlords are quietly breaking right now. Second, exactly what counts as normal wear and tear and what doesn't. And third, the one written notice your landlord is required to send you before touching a single dollar of your deposit. If they didn't, you may be entitled to double or even triple the amount they kept. In most U.S. states, your landlord is legally required to send you a written, itemized statement of any deductions from your deposit. Not a verbal conversation, not a text message, a written, itemized statement. And that statement must arrive within a specific window after you move out. In California, 21 days. In Texas, 30 days. In New York, 14 days. Miss that window, and in many states, your landlord automatically forfeits the right to keep any portion of your deposit. Not part of it, any of it. The entire deposit comes back to you, regardless of the condition of the apartment. The second law most landlords abuse involves a phrase they hope you don't understand: normal wear and tear. Every state in the U.S. recognizes this concept, and every state agrees on what it means. Normal wear and tear is the natural, unavoidable deterioration of a property that occurs simply from someone living there. Paint that fades after 4 years, wear and tear. Carpet that's slightly worn from walking, wear and tear. Small scuffs on walls from furniture placement, wear and tear. Your landlord cannot charge you for any of these, legally, full stop. What they can charge for is actual damage you caused. A hole punched in the wall, a stain that's been ground into the carpet, broken fixtures, missing fittings. The test is simple. Did this happen because you lived there or because you did something to it? The third law is the one most tenants never hear about, and it may be the most powerful. Before your landlord is allowed to deduct a single dollar from your deposit, they are required in most states to provide written notice of their intent to do so. That means a letter sent to your last known address within the legally required time window, detailing every single deduction with a corresponding amount. If that notice doesn't arrive, or if it arrives after the deadline, or if it fails to itemize each charge individually, you may be entitled to penalties on top of your full deposit return. In California, that penalty is twice the deposit amount. In some states, 3 times. Now, if your landlord has already illegally withheld your deposit, here's what you do next. You send a demand letter. A demand letter is a formal written notice stating that you believe a law was broken, the specific amount you are owed, a deadline for payment, typically 14 days, and a clear statement that small claims court follows if they don't comply. You don't need a lawyer to write one. You don't need legal training. You need 4 things: the facts, the amount, the deadline, and a stamp. Bookmark this video. You don't know when you're going to need it, but when you do, you'll know exactly what to do. If your landlord has already sent the demand letter and they've ignored it, the next step is small claims court, and we've already covered that, step by step, no lawyer needed, in the next video. Link is on screen right now. Subscribe so you never get caught off guard again. New video every week. And remember, this channel is for educational purposes only and does not constitute legal advice. For your specific situation, always consult a qualified attorney in your jurisdiction.